This is Trip Vanderwall, member at Miller Johnson in our Employee Benefits and Executive Compensation Practice Group. Welcome to the Benefits Lunch Break Series on February 17, 2021. As you can see, these are, for those of you that may be new to us, these are monthly webinars that we have specifically on the topic of benefits, and it may not always be health and welfare benefits. Sometimes I will have my colleagues who specialize more in the retirement and executive comp area join as I can prod them to do so. So this is just a look at some of the upcoming dates of benefit lunch breaks. And again, they are always going to be on the third Wednesday of the month at 12 p.m. Eastern time. All right, with that, we'll get started. And as indicated, this webinar is going to be on the Consolidated Appropriations Act, specifically with various reporting requirements related to mental health and substance use disorder benefits provided by group health plans. So again, today's topic, we're really going to focus on the NQTL, or non-quantitative treatment limitation reporting requirement under the Mental Health Parity and Addiction Equity Act as required by the Consolidated Appropriations Act of 2021. For those of you that have been playing along, you have noticed that there were a lot of other changes under the CAA that will or may impact your group health plan, such as the No Surprises Act and then various transparency requirements. Again, we plan on addressing these in more specific detail in the future, but as you will see, there was an important timing requirement with respect to this mental health and substance use disorder reporting that we thought it was appropriate to address this sooner rather than later. So for those of you that are interested, please tune in. We will, as we plan these out throughout the years, we will try to give you some advance warning on the topics of each webinar at least a week or two before we plan to host them. For those of you that are on the line that are Michigan-based employers with Michigan organizations, please note that the state of Michigan recently, in October of 2020, passed a state law that is very similar to the federal No Surprises Act and generally prohibits providers from balance billing and establishes some payment mechanisms more on the fully insured side. Before we really talk about the reporting requirements, let's talk about the Mental Health Parity and Addiction Equity Act kind of in general and kind of set the stage here. Next slide, please, Jeff. So on a very, very high level for group health plans that provide mental health or substance use disorder benefits, the Mental Health Parity and Addiction Equity Act requires that those benefits be provided in parity with any medical surgical benefits that are provided under the plan. As you can see, the Mental Health Parity and Addiction Equity Act defines mental health or substance use disorder benefits as benefits for items or services for mental health or substance use disorders as defined by one of these three current guidelines. And then maybe the question comes up is, what exactly is the medical surgical benefit? Those are not actually defined to my knowledge under the Mental Health and Addiction Equity Act, but would presumably be any type of benefit that does not meet the definition of a mental health or substance use disorder benefit. So what are the Mental Health Parity and Addiction Equity Act requirements? We divide these really, as you can see, into requirements that apply to annual and lifetime limits, which we'll address here, financial and quantitative treatment limitations, and then non-quantitative treatment limitations. So starting first with the annual and lifetime limits, if a plan, there's really two ways a plan can comply with requirements under the Mental Health Parity and Addiction Equity Act on annual and lifetime limits. The first is under this so-called 1/3 rule. And that's if a plan imposes annual or lifetime limits on less than 1/3 of the medical surgical benefits offered under the plan, it just cannot impose an annual or lifetime limit on mental health or substance use disorder benefits. Seems pretty straightforward. Now, there's a second compliance avenue, which is called the 2/3 rule. And if a plan, simply, aptly named, if a plan imposes an annual or lifetime limit on at least 2/3 of the medical surgical benefits offered by the plan, it can impose an annual or lifetime limit on mental health, or substance use disorder benefits within limitations. And so first, it can take basically the same annual or lifetime limit that is applicable to medical surgical benefits and apply that to mental health and substance use disorder benefits. So kind of all the medical, surgical, mental health, substance use disorder benefits are subject to the annual or the same annual or lifetime dollar limit. The second is impose a separate annual or lifetime limit on the mental health or substance use disorder benefits. But the requirement there is the separate limit has to be at least as high as the limit imposed on medical surgical benefits. And arguably, it could be higher, it just can't be less high. Now, let me note one thing. I think this is largely a technical or legal issue after the passage of the ACA. For those of you on the line are familiar with the ACA, you know that the ACA prohibits almost all plans. It prohibits non-grandfathered plans, which are most group health plans these days, from imposing actually it imposes, I think, restricts all group health plans. I apologize, all group health plans from imposing annual or lifetime dollar limits on the value of essential health benefits. And while a plan could still utilize an annual or dollar limit on the value on a non-essential health benefits, I think as a practical matter, most plans have removed annual or lifetime limits in their entirety. So the next requirement is those that apply to financial requirements or quantitative treatment limitations. And this is kind of a mouthful, so we're going to walk through this. We're going to spend a little bit of time on this, but not too much, because this is not really the crux of what the CAA reporting requirements apply to. So a plan generally cannot apply a financial requirement or a quantitative treatment limitation on mental health or substance use disorder benefits that is more restrictive than the predominant level or type of financial requirement or quantitative treatment limitation that applies to substantially all of the medical surgical benefits in the same classification. And we will talk about classifications more here in a few slides, but to give an example, one classification of which you need, one of the 6 classifications that you need to kind of divide all your plan's benefits in, are outpatient in-network. Or one of the classifications is the outpatient in-network classification. So if you're looking at that classification and you're looking at a financial requirement, such as, let's say, you have some deductibles, co-payments, or co-insurance that apply to services in that classification, you have to determine which type, deductible, co-payment, co-insurance, out-of-pocket maximum, applies to at least 2/3 of the medical surgical benefits in that classification, determined based on the expected plan spend. If a type of financial requirement or quantitative treatment limitations does not apply to at least 2/3 of the medical surgical benefits in that classification, you cannot apply that type of financial requirement or quantitative treatment limitation to any mental health or substance use disorder benefits in that classification. So again, substantially all means 2/3 based on the dollar amount of all plan payments for medical surgical benefits in the classification. So you're looking at the type, whether it be deductible or an annual or date or visit limitation, and saying, hey, if that doesn't apply to at least 2/3 of the medical surgical benefits in that classification, it's just off the table for applying to mental health or substance use disorder benefits, but only in that classification. Now, if you have, for example, more than one level of a financial requirement that applies to medical surgical benefits, you can only apply the one to mental health and substance use disorder benefits in that classification that applies to the predominant level of mental health, or I'm sorry, medical surgical benefits, which is 50%. So let's say, again, you have a co-payment that applies to at least 2/3 of the medical surgical benefits in a classification. You can then apply that co-payment requirement, or you can apply co-payments to mental health and substance use disorder benefits in that classification. But if you have multiple levels, and here at the end of the screen, I have maybe some benefits are $50, or some benefits are subject to a $50 copayment, some are subject to a $30 copayment, some are subject to a $10 copayment. You have to determine which applies to more than 50%. And if none of them do, you start aggregating. So you would put the 50 and the 30 together. Does those apply to at least 50% of the medical surgical benefits in that classification? If they do, then you can use a 30% copayment on mental health and substance use disorder benefits. But if you aggregate the 50 and 30 together and you're still not hitting 50% of medical surgical benefits, again, by expected plan spend, then maybe you have to add the benefits subject to the $10 copayment. And then the least restrictive is the $10 copayment, and that's what it can apply to mental health or substance use disorder benefits. Again, this is pretty complicated, but the good news is that these are mathematically based tests. So the extent that you are relying on a third-party administrator for a self-funded plan or insurer for your fully insured plan, it presumably has done or is aware of these requirements and has done some mathematically based testing to ensure that the plan complies with the Mental Health Parity and Addiction Equity Act's requirements on financial requirements and quantitative treatment limitations. Question here, how you determine the percentage of medical surgical benefits, utilization, schedule of benefits. So I think this has to do with determining how you determine whether a financial requirement or quantitative treatment limitation applies first to at least 2/3 of all the medical surgical benefits. And again, you're going to do that by the expected dollars spent by the plan. And the regulations clarify that when doing this analysis, you're supposed to look at the plan, the expected spend by the plan specifically, not necessarily by the carrier's book of business or the TPA's book of business. So each one of these plans should be determining the predominant level of financial requirement and quantitative treatment limitation in each classification based on that plan's expected spend of benefits that fall in those classifications. So again, there's a lot of data points or a lot of, there's some actuarial science that goes into that. But again, these are unlike, as you'll see when we get to the non-quantitative treatment limitations, the answer, can be determined using a mathematical based test rather than kind of, a facts and circumstances or gray area type test. So the final requirement under the Mental Health Parity and Addiction Equity Act is requirements that apply to non-quantitative treatment limitations. And really, this is kind of again, as I mentioned, the requirements that apply to financial limitations and quantitative treatment limitations can be determined using a mathematical based test. There's a lot more, the NQTL requirements are subject to much more interpretation, if you will. And so from a very high level, the basic requirement, under the terms of the plan as written and as operated. So keep in mind, if we have a plan that satisfies the Mental Health Parity and Addiction Equity Act requirements in writing, we may actually have to dig into to claims data to look to make sure it's being operated in compliance as well, because there's a requirement that it be written and operated in compliance with the Mental Health Parity and Addiction Equity Act. So under the terms of the plan, any processes, strategies, evidentiary standards, or other factors that are used to apply the NQTLs to mental health and substance use disorder benefits in a classification must be comparable to and applied no more stringently than the processes, strategies, evidentiary standards, or other factors used in applying those NQTLs to the medical surgical benefits in the same classification. And this, while it's a high-level overview, it becomes very important because it is ultimately going to serve as the basis of what you may be required to report to the Department of Labor, IRS, or Health and Human Services if they come asking about mental health parity compliance. So what is a non-quantitative treatment limitation? Well, it's it's any treatment limitation under the plan that can't be expressed in a quantitative measure, like a number of days that treatment will be provided, a number of visits that treatment will be provided. Anything that's non-quantitative is going to fall under these NQTLs. So medically appropriate, medically necessary decisions, those requirements that are subject to pre-authorization or prior review, things like that. This is a large list of NQTL examples that have been specifically looked at by the Department of Labor before. And frankly, let me just specify that not all of these non-qualified treatment limitations violate the mental health parity. Again, they're not going to violate mental health parity as long as the processes, strategies, and factors used to determine these NQTLs are comparable between mental health, substance use disorder benefits, and then those of medical surgical benefits. So I mentioned that testing actually depends on classification. So we're really looking at this testing for not the annual or lifetime limits, but for the financial requirements, quantitative treatment limitations, and non-quantitative treatment limitations. The parity is required to be within these 6 general classifications. Again, inpatient, in network, inpatient, out of network, outpatient, in network, outpatient, out of network, emergency care, and prescription drugs. There's no other classifications that are allowed under the Mental Health Parity Act or the implementing regulations. However, there are some specifically allowed subclassifications. So network providers, so if you're dealing with a plan that has a network provider, you may subclassify based on network tier. So some plans may use different network tiers. So for example, I may go to this smaller network of providers and I'm not subject to any type of out-of-pocket cost sharing. Or if I go to this other larger subsection of network tiers, I pay a slightly more or out-of-pocket cost sharing requirement. But it's different than going to an out-of-network provider where I could often be balance billed for any payment not made by the plan. And then outpatient benefits, so either the outpatient in-network or outpatient out-of-network classifications can be further subdivided into 1, office visits, and 2, all other outpatient items and services. So the Consolidated Appropriations Act, what did it change? The CAA amended ERISA, it amended the Internal Revenue Code, and it amended the Public Health Service Act, really all in the same ways, to require insurers and plans to perform an analysis of the NQTLs imposed by the plan to ensure compliance with mental health parity. So because not all employers, for example, are subject to ERISA. Church employers, non-federal governmental employers are not subject to ERISA. But because it amended the Internal Revenue Code and the Public Health Service Act, it seems like there's really no escape from this requirement for any type of group health plan. Now, having said that, I should note that there are some non-federal governmental employers that may opt out of even being subject to the Mental Health Parity and Addiction Equity Act, but I'm not familiar that that has been a popular exemption. For those of you on the line that are with an organization that has a fully insured group health plan, it appears that the insurer must perform this analysis. But again, I think as we go through the rest of this presentation, it will be important for you to ask questions of your insurer to make sure that the plan is in compliance. But for those self-funded group health plans, the obligation to perform this analysis is actually on the employer or plan sponsor. Now, again, having said that, most of the information necessary, if not all of the information necessary to perform this analysis is going to be in the hands of the entity that administers your self-funded health plan. So we are absolutely going to need to rely on their assistance either to help prepare this analysis or do it on our behalf. Ultimately, what the CAA requires is for those plans that provide mental health and substance use disorder benefits that are subject to mental health parity, that it perform, and again, this is the insurer for fully insured plans or plan sponsor for self-funded plans, must perform and document comparative analyses of the design and application of the NQTLs, the non-quantitative treatment limitations, to ensure compliance with mental health parity. So this comparative analysis must, going back to the beginning, must demonstrate that the processes, strategies, evidentiary standards, and other factors used to apply the NQTLs to mental health and substance use disorder benefits in both writing and in operation are comparable to those that are applied and are applied no stringently than the processes, strategies, evidentiary standards, and other factors used to apply the NQTLs to medical surgical benefits, again, within the same classification. So this comparative analysis, and we have very little guidance on what it's to look like, this basically must demonstrate that the plan's non-quantitative treatment limitations applicable to mental health and substance use disorder benefits complies with mental health parity. I see another question. That's a great question. How often must the comparative analysis be conducted and documented? At this point, there is no specific timing requirements. You will see that it is possible that beginning this past February 10, that the federal agencies, the federal government, request documentation of this. But I would say once you've done it, you're probably good until your plan design changes. And if your plan design changes, that may not be, or may not require a complete redo of the comparative analysis, but may require an update of the comparative analysis. Because frankly, if you have to demonstrate this to the federal government, I would say it's going to be the starting point is that you're going to have to demonstrate compliance at the time the agency asks. And, if you say, well, we have this comparative analysis that we did, back in 2021, shortly after the CAA was just passed, but now it's 2028, and our plan design has changed significantly since then. You're not going to be in good shape if the feds come looking for the comparative analysis or additional documentation. So as I mentioned, beginning February 10, 2021, so last week, the insurer or plan must provide the feds, either the Department of Labor, IRS, or HHS, depending on which the jurisdiction of which agency has jurisdiction over your plan. I would say for most private employers, it's going to be the Department of Labor. For church and non-governmental employers, probably more likely to be HHS. But you're going to have to provide the comparative analysis along with additional following information, but only if the DOL or the agency requests that information. And in addition, so the borderline request would be the comparative analysis, but it's also likely the agencies have said, don't just look at the comparative analysis and decide whether or not the plan complies with the Mental Health Parity Act based on the comparative analysis alone. You may need to request additional documentation, such as specific plan or coverage terms regarding those NQTLs, the factors used to determine them and how they're applied to mental health and substance use and medical surgical benefits, evidentiary standards or other source or evidence relied on to develop these factors. And then you're actually supposed to have a specific finding, you being the plan sponsor or the insurer, specific findings and conclusions about whether these analyses indicated compliance or non-compliance with mental health parity. And of course, if our findings or conclusions demonstrate non-compliance, we presumably have an action item to take and redesign our plan to remove those problem areas to make sure that our plan does comply. Now, keep in mind that at least initially, the agencies are supposed to make these requests of at least 20 plans or employers per year. It's not entirely clear if the Department of Labor has to do 20, the IRS has to do 20, and HHS has to do 20. So a total of 60 per year, or if there's some type of consolidation between the three of them. But the good news is the statute at least appears to direct the agencies to focus on those plans or insurers where it is been identified that there may be non-compliance issues. So that doesn't mean that just because your plan is in compliance that you won't get this request, but to the extent that maybe the agencies have received department complaints, there's been lawsuits filed against your plan, state insurance agencies had started poking around and alert the federal agencies, that is more likely to lead the feds to follow up and make these requests. Finally, one other point before we move on is that these disclosure requests are not entirely new. The regulations issued under mental health parity back in, I think, November of 2013, so almost 8 years ago now, actually indicated that a lot of this information was subject to participant requests, of which the employer has to provide within 30 days or can be subject to financial penalties if the participant requests it. So there's probably a lot of overlap in that information, but I think on a practical level, very few plans had participants request this type of information. If that came up, it was more likely in the context of a denial of a certain mental health or substance use disorder benefit. But again, let me just be clear that the CAA does not require plans to perform this comparative analysis upon request. All of these plans should be performing these comparative analysis and have it ready for the federal agencies if and when they should request it. So what are the penalties under for non-compliance? So if the feds determine that the plan's NQTLs are not compliant, you are going to get, you are going to have to, tell or indicate to the feds what actions you or your insurer are going to take to become compliant. And then they're arguably going to give you a 45-day determination period after their initial determination of noncompliance to come into compliance. And after that 45-day period, they're going to make another determination. And if they determine noncompliance again, within 7 days of this secondary determination, the agencies, and it's a little bit unclear if the agencies are going to do this themselves or going to force the plan or the plan sponsor, the insurer or plan sponsor to notify, but basically any participant in the plan is going to be notified that the plan does not comply with the requirements of the Mental Health Parity and Addiction Equity Act. So if you think about that, that is not a notification we want going out to our participants. It could start to serve, on the retirement side of the benefits world, we have seen a surprising uptick of investment fee-based litigation, especially on the class basis. I think that participants starting to get this information that a plan does not comply with mental health parity, you yourself may not have any damages, but there may be some type of lawsuit or plaintiff attorneys that are out looking for that to instigate more class action lawsuits like we've seen on the retirement side. So again, I think most employers and plan sponsors, again, whether you have a self-funded or fully insured plan, are going to want to avoid these notifications going out to the extent possible. The agencies will also file an annual report to Congress, which is going to be made publicly available. And if you're non-compliant, I think the thing that's going to stick out to me is they're going to include the specific identity of the insurer or the plan that was determined not to be in compliance. There's also some other conclusions, some specifications that the agencies will have to put in there, and then what action items plans tried to take to achieve within 40-day, 5-day compliance. Again, I think for most of you on the line, the bigger thing is if you end up on this report, your specific plan name is going to be listed on that report to Congress as kind of a naughty list that your plan does not comply. So what are the next steps? Boy, it would be helpful to have some additional guidance from the departments on this information and what's required. For those of you that are interested, there is a self-compliance tool that the Department of Labor recently posted. I think it was October 23 of 2020, so at the end of last year. And it was an updated self-compliance tool of something they had previously posted. If you go through that, it's not going to tell you how to do the comparative analysis. But it is helpful in that it identifies, plan designs that are potentially problematic. But what should you as employers be doing? I recommend you reach out to your TPAs and your insurers to ask them how they intend to comply. Are they looking into preparing this comparative analysis? Are they willing to do it on your behalf? Again, even if you're a fully insured plan, I think it is prudent to ask your insurers about this, because if, arguably there's no penalty that will fall to you for non-compliance. But if the agencies ask the insurer to provide this information and they're not able to do so in a compliant manner, your participants in your group health plan are going to get this notice that the plan fails to comply, and I think there's going to be some blowback from that. And of course, if you're a self-funded plan, this is on your obligation. So again, TPAs are going to play a vital part in the preparation, or at least in the assistance of the preparation of this comparative analysis. So I think the next question is to your TPA, will you do this? Will you send me the information to do this on our own? Will you help me do this? How are we going to work together to get this done? And for TPAs that are not willing to do this on your behalf, I think they have to provide the data, but I'm wondering if any will take the position that some of this information is proprietary. And even though they may be willing to turn it over to the departments upon request, because this information is specifically excluded from FOIA requests under the law, are they willing to give it to you and potentially risk its leaking out into the market? All areas I think that need to be explored as we work with our TPA partners to prepare these comparative analysis and having other documentation ready to go should we ever need to not only respond to a request from the federal government, but again, maybe do a self-compliance check that the plan does comply with the Mental Health Parity Act. Legal review, we are here to assist. Again, this is a new process for all of us. And again, I think we can provide a legal opinion of some ways we can assist, providing a legal opinion of your TPA prepared comparative analysis. If your TPA is not going to prepare this for you, we may be able to help you prepare as long as we can get the necessary information from the TPA. And we can also just do a higher level review of your plan design, much similar to what we would think that the Department of Labor would do in a standard health plan audit, and identify problem areas with respect to mental health compliance. All right, we have a number of questions. I will try to get through some of them. Again, if you have to sign off, I know I've gone a little bit long here. We do post this webinar to the firm's YouTube page, so you can always come back and watch it later. So the question is, if the plan does not have any limits on number of visits or charges the same copay for mental health and substance use disorder benefits, there is no need for an analysis, correct? I would say that's actually incorrect. So remember, if we're talking about limits on number of visits or charges on copay, those are all quantitative financial requirements or quantitative treatment limitations. And the comparative analysis is specifically addressed at non-quantitative treatment limitations. So eliminating those types of copays, deductibles, visit limits is not going to get you around this, because again, this is more addressed towards, do we have medically necessary determinations that comply? Do we have pre-authorization requirements on mental health and substance use disorder benefits in a way that's not comparable to medical surgical benefits on that classification? So again, I think it's more complicated because the comparative analysis only has to do an analysis of the non-quantitative treatment limitations. It does not have to include any analysis, at least at this point, of the financial requirements or quantitative treatment limitations that may apply to medical, surgical, or mental health or substance use disorder benefits. And I think removing all NQTLs on mental health and substance use disorder benefits is not even a practical solution, to be honest. So again, I don't think that's a necessary solution to this particular problem. Does this reporting requirement apply to Medicare Advantage plans? I don't have any reason why it wouldn't. Again, assuming the Medicare Advantage plan is providing mental health and substance use disorder benefits. But again, Medicare Advantage plans fully insured, so at least the onerous is going to fall more on the insurer than it is the employer sponsor in the context of a group Medicare Advantage plan. Would an HRA that is reimbursing deductibles, coinsurance, and copayments imposed by fully insured plans be subject to doing this analysis? That's a great question. I don't know the answer to that. My suspicion would be there may be some type of carve-out arrangement for HRAs, but I don't want to, again, that's my suspicion. I don't know that for a fact. Feel free to follow up with me if you'd like us, like to look into that in further detail. Another question is, do these requirements apply to retiree-only health plans? That's another great question that I don't have the answer to, unfortunately. I'm sorry, off the top of my head. Again, if the retiree-only plan provided mental health and substance use disorder benefits, I think it arguably would apply. I'm not aware of a specific carve-out for retiree-only plans, but there are, a number of carve-outs for retiree-only plans out there. So again, that may be something we want to look at a little bit further to answer that more definitively. With that, it looks like that is all the questions that we have. Thanks again for joining us, and hope to see you back the third Wednesday of next month, hope in March 17th, I believe the date was, the third Wednesday in March. Hopefully, for those that you at least are geographically closer to me, it'll be a little warmer by that time frame in March. Yes, March 17th. So with that, we are all done for the day. Everybody have a great day and great rest of the week. Thanks. Bye.